Hello, everyone. Today's case is Regents of University of California versus Bakke. This is the seminal affirmative action in higher admissions. So this is the first, I think it's one of the first cases regarding this, at least in the university area. I know might be some areas prior to that, but let's get into it. The Medical School of the University of California at Davis, hereinafter Davis, had two admissions programs for the entering class of 100 students: the regular admissions program and the special admissions program. Under the regular procedure, candidates whose overall undergraduate grade point averages fell below 2.5 on a scale of 4 were summarily rejected. About 1 out of 6 applicants was then given an interview, following which each was rated on a scale of 1 to 100 by each of the committee members, 5 in 1973 and 6 in 1974. His rating being based on the interviewer's summaries, his overall grade point average, his science courses grade point average, his medical college admissions test, MCAT, scores, letters of recommendation, extracurricular activities, and other biographical data, all of which resulted in a total benchmark score. The full admissions committee then made offers of admission on the basis of their review of the applicant's file and his score. Considering and acting upon applications as they were received, the committee chairman was responsible for placing names on the waiting list and had discretion to include persons with special skills. A separate committee, a majority of whom were members of minority groups, operated the special admissions program. The 1973 and 1974 application forms, respectively, asked candidates whether they wished to be considered as economically and or educationally disadvantaged applicants and members of a minority group: blacks, Chicanos, Asians, American Indians. If an applicant of a minority group was found to be disadvantaged, he would be rated in a manner similar to the one employed by the General Admissions Committee. Special candidates, however, did not have to meet the 2.5 grade point cutoff and were not ranked against candidates in the general admission process. About 1/5 of the special applicants were invited for interviews in 1973 and 1974, following which they were given benchmark scores, and the top choices were then given to the General Admission Committee, which could reject special candidates for failure to meet course requirements or other specific deficiencies. The special committee continued to recommend candidates until 16 special admissions selections had been made. During a 4-year period, 63 minority students were admitted to Davis under the special program and 44 under the general program. No disadvantaged whites were admitted under the special program, though many applied. Respondent, a white male, applied to Davis in 1973 and 1974, in both years being considered only under the general admissions program. Though he had a 468 out of 500 score, impressive, in 1973, he was rejected since no general applicants with scores less than 470 were being accepted after respondent's application, which was filed late in the year, had been processed and completed. At that time, 4 special admission slots were still unfilled. In 1974, respondent applied early, and though he had a total score of 549 out of 600, he was again rejected. In neither year was his name placed on the discretionary waiting list. In both years, special applicants were admitted with significantly lower scores than respondents. After his second rejection, respondent filed this action in state court for mandatory injunctive and declaratory relief to compel his admission to Davis, alleging that the special admissions program operated to exclude him on the basis of his race in violation of the Equal Protection Clause of the 14th Amendment, a provision of the California Constitution and subsection 601 of Title VI of the Civil Rights Act of 1964. Which provides, inter alia, that no person shall, on the ground of race or color, be excluded from participating in any program receiving federal financial assistance. Petitioner cross-claimed for a declaration that its special admissions program was lawful. The trial court found that the special program operated as a racial quota because minority applicants in that program were rated only against one another, and 16 places in the class of 100 were reserved for them. Declaring that petitioner could not take race into account in making admissions decisions, the program was held to violate the federal and state constitutions and Title VI. Respondent's admission was not ordered, however, for lack of proof that he would have been admitted but for the special program. The California Supreme Court, applying a strict scrutiny standard, concluded that the special admissions program was not the least intrusive means of achieving the goals of the admittedly compelling state interests of integrating the medical profession and increasing the number of doctors willing to serve minority patients. Without passing on the state constitutional or federal statutory grounds, the court held that petitioner's special admissions program violated the Equal Protection Clause. Since petitioner could not satisfy its burden of demonstrating that respondent, absent the special program, would not have been admitted, the court ordered his admission to Davis. Held. The judgment below is affirmed insofar as it orders respondent's admission to Davis and invalidates petitioner's special admissions program, but it reverses insofar as it prohibits petitioners from taking race into account as a factor in its future admissions decisions. Mr. Justice Powell concluded, that's right, this was like a plurality, real split decision. 1. Title VI prescribes only those racial classifications that would violate the Equal Protection Clause if employed by a state or its agencies. Racial and ethnic classifications of any sort are inherently suspect and call for the most exacting judicial scrutiny. While the goal of achieving a diverse student body is sufficiently compelling to justify consideration of race in admissions decisions under some circumstances, petitioner's special admissions program, which forecloses consideration to persons like respondent, is unnecessary to the achievement of this compelling goal and therefore invalid under the Equal Protection Clause. 3. Since petitioner could not satisfy its burden of proving that respondent would not have been admitted even if there had been no special admission program, he must be admitted. Mr. Justice Brennan, Mr. Justice White, Mr. Justice Marshall, and Mr. Justice Blackmun concluded. Title VI prescribes only those racial classifications that would violate the Equal Protection Clause if employed by a state or its agencies. Racial classifications call for a strict judicial scrutiny. Nonetheless, the purpose of overcoming substantial chronic minority underrepresentation in the medical profession is sufficiently important to justify petitioner's remedial use of race. Thus, the judgment below must be reversed in that it prohibits race from being used as a factor in university admissions. Mr. Justice Stevens, joined by the Chief Justice, Mr. Justice Stewart, and Mr. Justice Rehnquist, being of the view that whether race can ever be a factor in admission policy is not an issue here, that Title VI applies, and that respondent was excluded from Davis in violation of Title VI, concurs in the court's judgment insofar as it affirms the judgment of the court below ordering respondent admitted to Davis. Justice Powell announced the court's judgment and filed an opinion expressing his views on the case in parts 1, 3A, and 5C, of which Justice White joined, and in parts 1 and 5C, in which Brennan, Marshall, and Blackmun joined. Brennan, White, Marshall, and Blackmun filed an opinion concurring in the judgment in part and dissenting in part. Justice White and Justice Marshall and Justice Blackmun filed separate opinions. Stevens filed an opinion concurring in the judgment in part and dissenting in part, while Chief Justice Berger and Stewart and Rehnquist joined. All right, so where is the case? Mr. Justice Powell announced the judgment of the court. This case presents a challenge to the special admissions program of the petitioner, the Medical School of the University of California at Davis, which is designed to assure the admission of a specific number of students from certain minority groups. The Superior Court of California sustained respondent's challenge, holding that petitioner's program violated the California Constitution, Title VI of the Civil Rights Act of 1964, and the Equal Protection Clause of the 14th Amendment. The court enjoined petitioner for considering respondent's race or the race of any other applicant in making admissions decisions. It refused, however, to order respondent's admission to the medical school, holding that he had not carried his burden of proving that he would have been admitted, but for the constitutional and statutory violations. Let me reread that. It refused, however, to order the respondent's admission to the medical school, holding that he had not carried his burden of proving that he would have been admitted, but for the constitutional and statutory violations. The Supreme Court of California affirmed those portions of the trial court's judgment, declaring the special admissions program unlawful and enjoining petitioner from considering the race of any applicant. It modified that portion of the judgment, denying respondent's requested injunction, and directed the trial court to order his admission. For the reasons stated in the following opinion, I believe that so much of the judgment of the California court as holds petitioner's special admissions program unlawful and directs that respondent be admitted to the medical school must be affirmed. For the reasons expressed in a separate opinion, my brothers, the Chief Justice, Mr. Justice Stewart, Mr. Justice Rehnquist, and Mr. Justice Stevens concur in this judgment. I also conclude for the reasons stated in the following opinion that the portion of the court's judgment enjoining petitioner from according any consideration to race in its admission process must be reversed. For reasons expressed in separate opinions, my brothers Mr. Justice Brennan, Mr. Justice White, Mr. Justice Marshall, and Mr. Justice Blackmun concur in this judgment. Affirmative part and reversed part. The Medical School of the University of California at Davis opened in 1968 with an entering class of 50 students. In 1971, the size of the entering class was increased to 100 students, at a level at which it remains. No admissions program for disadvantaged or minority students existed when the school opened, and the first class contained 3 Asians, but no blacks, no Mexican Americans, and no American Indians. Over the next 2 years, the faculty devised a special admissions program to increase the representation of disadvantaged students in each medical school class. The special program consisted of a separate admissions system operating in coordination with the regular admissions process. Under the regular admissions procedure, a candidate could submit his application to the medical school beginning in July of the year preceding the academic year for which admission was sought. Because of the large number of applications, the admissions committee screened each one to select candidates for further consideration. Candidates whose overall undergraduate grade point averages fell below 2.5 on a scale of 4 were summarily rejected. About 1 out of 6 applicants was invited for a personal interview. Following the interviews, each candidate was rated on a scale of 1 to 100 by his interviewers and 4 other members of the admissions committee. The rating embraced the interviewer's summaries, the candidate's overall grade point average in science courses, scores on the Medical College Admissions Test, MCAT, letters of recommendation, extracurricular activities, and other biographical data. The ratings were added together to arrive at each candidate's benchmark score. Since 5 committee members rated each candidate in 1973, a perfect score was 500. In 1974, 6 members rated each candidate so that a perfect score was 600. The full committee then reviewed the file and scores of each applicant and made offers of admission on a rolling basis. The chairman was responsible for placing names on the waiting list. They were not placed in strict numerical order. Instead, the chairman had discretion to include persons with, quote, special skills. The special admissions program operated with a separate community, a majority of whom were members of minority groups. On the 1973 application form, candidates were asked to indicate whether they wished to be considered as economically and/or educationally disadvantaged applicants. On the 1974 form, the question was whether they wished to be considered as members of a minority group, which the medical school apparently viewed as blacks, Chicanos, Asians, and American Indians. If these questions were answered affirmatively, the application was forwarded to the Special Admissions Committee. No formal definition of disadvantaged was ever produced, but the chairman of the special committee screened each application to see whether it reflected economic or educational deprivation. Having passed this initial hurdle, the applications that were rated by the special committee in a fashion similar to that used by the general admissions committee, except that special candidates did not have to meet the 2.5 grade point average cutoff applied to regular applicants. About 1/5 of the total number of special applicants were invited for interviews in 1973 and 1974. Following each interview, the special committee assigned each special applicant a benchmark score. The special committee then presented its top choices to the general admissions committee. The latter did not rate or compare the special candidates against the general applicants, but could reject recommended special candidates for failure to meet course requirements or other specific deficiencies. The special committee continued to recommend special applicants under a number prescribed by faculty vote were admitted. While the overall class size was still 50, the prescribed number was 8 in 1973 and 1974 when the class size had doubled to 100. The prescribed number of special admissions also doubled to 16. From the year of the increase in class size, 1971 through 1974, the special program resulted in the admission of 21 black students, 30 Mexican Americans, and 12 Asians, for a total of 63 minority students. Over the same period, the regular admissions program produced 1 black, 6 Mexican Americans, and 37 Asians, for a total of 44 minority students. Although disadvantaged whites applied to the special program in large numbers, none received an offer of admission through that process. Indeed, in 1974 at least, the special committee explicitly considered only disadvantaged special applicants who were members of one of the designated minority groups. Alan Bakke is a white male who applied to the Davis Medical School in both 1973 and 1974. In both years, Bakke's application was considered under the general admissions program, and he received an interview. His 1973 interview was with Dr. Theodore C. West, who considered Bakke a very desirable applicant to the medical school. Despite a strong benchmark score of 468 out of 500, Bakke was rejected. His application had come late in the year, and no applicants in the general admissions process with scores below 470 were accepted after Bakke's application was completed. There were 4 special admissions slots unfilled at that time, however, for which Bakke was not considered. After his 1973 rejection, Bakke wrote to Dr. George H. Lowry, Associate Dean and Chairman of the Admissions Committee, protesting that the special admissions program operated as a racial and ethnic quota. Bakke's 1974 application was completed early in the year. His student interviewer gave him an overall rating of 94, finding him friendly, well-tempered, conscientious, and delightful to speak with. His faculty interviewer was, by coincidence, the same Dr. Lowry to whom he had written in protest of the special admissions program. Dr. Lowry found Bakke rather limited in his approach to the problems of the medical profession and found disturbing Bakke's very definite opinions, which were based more on his personal viewpoints than upon a study of the total problem. Dr. Lowry gave Bakke the lowest of his 6 ratings, an 86. His total was 549 out of 600. Again, Bakke's application was rejected. In neither year did the chairman of the admissions committee, Dr. Lowry, exercise his discretion to place Bakke on the waiting list. In both years, applicants were admitted under the special program with grade point averages, MCAT scores, and benchmark scores significantly lower than Bakke's. After the second rejection, Bakke filed the instant suit in the Superior Court of California. He sought mandatory, injunctive, and declaratory relief, compelling his admission to the medical school. He alleged that the medical school's special admissions program operated to exclude him from the school on the basis of his race, in violation of his rights under the Equal Protection Clause of the 14th Amendment. The university cross-complained for a declaration that its special admissions program was lawful. The trial court found that the special program operated as a racial quota because minority applicants in the special program were rated only against each other, and 16 places in the class of 100 were reserved for them. Declaring that the university could not take race into account in making admissions decisions, the trial court held the challenged program violative of the federal constitution, the state constitution, and Title VI. The court refused to order Bakke's admission, however, holding that he had failed to carry his burden of proving that he would have been admitted but for the existence of the special program. Bakke appealed from the portion of the trial court judgment denying him admission, and the university appealed from the decision that its special admissions program was unlawful and the order enjoining it from considering race in the processing of applications. The Supreme Court of California transferred the case directly from the trial court because of the importance of the issues involved. The California court accepted the findings of the trial court with respect to the university's program. Because the special admissions program involved a racial classification, the Supreme Court held itself bound to apply strict scrutiny. It then turned to the goals the university presented as justifying the special program. Although the court agreed that the goals of integrating the medical profession and increasing the number of physicians willing to serve members of minority groups were compelling state interests, it concluded that the special admissions program was not the least intrusive means of achieving those goals. Without passing on the state constitutional or the federal statutory grounds cited in the trial court's judgment, the California court held that the Equal Protection Clause of the 14th Amendment required that no applicant may be rejected because of his race in favor of another who is less qualified as measured by standards applied without regard to race. Turning to Bakke's appeal, the court ruled that since Bakke had established that the university had discriminated against him on the basis of his race, the burden of proof shifted to the university to demonstrate that he would not have been admitted even in the absence of the special admissions program. The court analogized Bakke's situation to that of a plaintiff under Title VII of the Civil Rights Act of 1964. On this basis, the court initially ordered a remand up for the purpose of determining whether, under the newly allocated burden of proof, Bakke would have been admitted to either the 1973 or the 1974 entering class in the absence of the special admissions program. In its petition for rehearing below, however, the university conceded its inability to carry that burden. The California court thereupon amended its opinion to direct that the trial court enter judgment ordering Bakke's admission to the medical school. That order was stayed pending review in this court. We granted certiorari to consider the important constitutional issue. In this court, the parties neither briefed nor argued the applicability of Title VI of the Civil Rights Act of 1964. Rather, as had the California court, they focused exclusively upon the validity of the special admissions program under the Equal Protection Clause. Because it was possible, however, that a decision on Title VI might obviate resort to constitutional interpretation, we requested a supplementary briefing on the statutory issue. At the outset, we faced the question whether a right of action for private parties exists under Title VI. Respondent argues that there is a private right of action invoking the test set forth in Court v. Ashe. He contends that the statute creates a federal right in his favor, that legislative history reveals an intent to permit private actions, that such actions would further the remedial purposes of the statute, and that enforcement of federal rights under the Civil Rights Act generally is not relegated to the states. In addition, he cites several lower court decisions which have recognized or assumed the existence of a private right of action. Petitioner denies the existence of a private right of action, arguing that the sole function of subsection 601 was to establish a predicate for administrative action under subsection 602. In its view, administrative curtailment of federal funds under that section was the only sanction to be imposed upon recipients that violated subsection 601. Petitioner also points out that Title VI contains no explicit grant of a private right of action, in contrast to Titles 2, 3, 4, and 7 of the same statute. We find it unnecessary to resolve this question in the instant case. The question of respondents' right to bring an action under Title VI was neither argued nor decided in either of the courts below, and this court has been hesitant to review questions not addressed below. We therefore do not address this difficult issue. Similarly, we need not pass upon petitioner's claim that private plaintiffs under Title VI must exhaust administrative remedies. We assume, only for the purposes of this case, that respondent has a right of action under Title VI. The language of subsection 601, like that of the Equal Protection Clause, is majestic in its sweep. No person in the United States shall, on the ground of race, color, or national origin, be excluded from participation in, be denied the benefit of, or be subjected to discrimination under any program or activity receiving federal financial assistance. The concept of discrimination, like the phrase equal protection of the laws, is susceptible to varying interpretations. For as Mr. Justice Holmes declared, a word is not a crystal, transparent and unchanged. It is the skin of a living thought that may vary greatly in color and content according to the circumstances and the time in which it was used. We must therefore seek whatever aid is available in determining the precise meaning of the statutes before us. Examination of the voluminous legislative history of Title VI reveals that a congressional intent to halt federal funding of entities that violate a prohibition of racial discrimination similar to that of the Constitution. Although isolated statements of various legislatures taken out of context can be marshaled in support of the proposition that subsection 601 enacted a purely colorblind scheme without regard to the reach of the Equal Protection Clause, these comments must be read against the background of both the problem that Congress was addressing and the broader view of the statute that emerges from a full examination of the legislative debates. The problem confronting Congress was discrimination against African American citizens at the hands of recipients of federal monies. Indeed, the color blindness pronouncements cited in the margin at Note 19 generally occur in the midst of extended remarks dealing with the evils of segregation in federally funded programs. Over and over again, proponents of the bill detailed the plight of African Americans seeking equal treatment in such programs. There simply was no reason for Congress to consider the validity of hypothetical preferences that might be accorded minority citizens. The legislatures were dealing with the real and pressing problem of how to guarantee those citizens equal treatment. In addressing that problem, supporters of Title VI repeatedly declared that the bill enacted constitutional principles. For example, Representative Seller, the chairman of the House Judiciary Committee and floor manager of the legislation in the House, emphasized this in introducing the bill. The bill would offer assurance that hospitals financed by federal money would not deny adequate care to African Americans. It would prevent abuse of food distribution programs whereby African Americans have been known to be denied food surplus supplies when white persons were given such food. It would assure African Americans the benefits now accorded only white students in programs of higher education, financed by federal funds. It would, in short, assure the existing right of equal treatment in the enjoyment of federal funds. It would not destroy any rights of private property or freedom of association. Other sponsors shared Representative Seller's view that Title VI embodied constitutional principles. In the Senate, Senator Humphrey declared that the purpose of Title VI was to ensure that federal funds are spent in accordance with the Constitution and the moral sense of the nation. Senator Ribicoff agreed that Title VI embraced the constitutional standard. Basically, there is a constitutional restriction against discrimination in the use of federal funds, and Title VI simply spells out the procedure to be used in enforcing that restriction. Other senators expressed similar views. Further evidence of the incorporation of a constitutional standard into Title VI appears to be repeated refusals of the legislation's supporters precisely to define the terms discrimination. Opponents sharply criticized this failure, but proponents of the bill merely replied that the meaning of discrimination would be made clear by reference to the Constitution or other existing law. For example, Senator Humphrey noted the relevance of the Constitution. As I have said, the bill has a single purpose. That purpose is to give fellow citizens, African Americans, the same rights and opportunities that white people take for granted. This is no more than what was preached by the prophets and by Christ himself. It is no more than what our Constitution guarantees. In view of the clear legislative intent, Title VI must be held to proscribe only those racial classifications that would violate the Equal Protection Clause of the Fifth Amendment. Petitioner does not deny that decisions based on race or ethnic origin by faculties and administrations of state universities are reviewable under the 14th Amendment. For his part, respondent does not argue that all racial or ethnic classifications are per se invalid. The parties do disagree as to the level of judicial scrutiny to be applied to the special admissions program. Petitioner argues that the court below erred in applying strict scrutiny, as this inexact term has been applied in our cases. That level of review, petitioner asserts, should be reversed for classifications that disadvantage discrete and insular minorities. Respondent, on the other hand, contends that the California court correctly rejected the notion that the degree of judicial scrutiny accorded a particular racial or ethnic classification hinges upon membership in a discrete and insular minority. Well, let me back up. A particular racial or ethnic classification hinges upon membership in a discrete and insular minority and duly recognizes that the rights established by the 14th Amendment are personal rights. En route to this crucial battle over the scope of judicial review, the parties fight a sharp preliminary action over the proper characterization of the special admissions program. Petitioner prefers to view it as establishing a goal of minority representation in the medical school. Respondent, echoing the courts below, labels it a racial quota. The semantic distinction is beside the point. The special admissions program is undeniably a classification based on race and ethnic background, to the extent that there existed a pool of at least minimally qualified minority applicants to fill the 16 special admissions seats. White applicants could compete only for 84 seats in the entering class, rather than the 100 open to minority applicants. Whether this limitation is described as a quota or a goal, it is a line drawn on the basis of race and ethnic status. The guarantees of the 14th Amendment extend to all persons. Its language is explicit. No state shall deny to any person within its jurisdiction the equal protection of the laws. It is settled beyond question that the rights created by the first section of the 14th Amendment are, by its terms, guaranteed to the individual. The rights established are personal rights. The guarantee of equal protection cannot mean one thing when applied to one individual and something else when applied to a person of another color. If both are not accorded the same protection, then it is not equal. Nevertheless, petitioner argues that the court below erred in applying strict scrutiny to the special admissions program because white males, such as respondent, are not a discrete and insular minority, requiring extraordinary protections from the majoritarian political process. This rationale, however, has never been invoked in our decisions as a prerequisite to subjecting racial or ethnic distinctions to strict scrutiny, nor has this court held that discreteness and insularity constitute necessary preconditions to a holding that a particular classification is invidious. These characteristics may be relevant in deciding whether or not to add new types of classifications to the list of suspect categories, or whether a particular classification survives close examination. Racial and ethnic classifications, however, are subject to stringent examination without regard to these additional characteristics. We declared as much in the first cases explicitly to recognize racial distinctions as suspect. Distinctions between citizens solely because of their ancestry are by their very nature odious to a free people whose institutions are founded upon the doctrine of equality. All legal restrictions which curtail the civil rights of a single racial group are immediately suspect. That is not to say that all such restrictions are unconstitutional. It is to say that courts must subject them to the most rigid scrutiny. The court has never questioned the validity of those pronouncements. Racial and ethnic distinctions of any sort are inherently suspect and thus call for the most exacting judicial examination. This perception of racial and ethnic distinctions is rooted in our nation's constitutional and demographic history. The court's initial view of the 14th Amendment was that its one pervading purpose was the freedom of the slave race, the security and firm establishment of that freedom, and the protection of the newly made freeman and citizen from the oppressions of those who had formerly exercised dominion over him. The Equal Protection Clause, however, was virtually strangled in infancy by post-Civil War judicial reactionism. It was relegated to decades of relative desuetude, while the Due Process Clause of the 14th Amendment, after a short germinal period, flourished as a cornerstone in the court's defense of property and liberty of contract. In that cause, the 14th Amendment's one pervading purpose was displaced. It was only as the era of substantive due process came to a close that the Equal Protection Clause began to attain a genuine measure of vitality. By that time, it was no longer possible to peg the guarantees of the 14th Amendment to the struggle for equality of one racial minority. During the dormancy of the Equal Protection Clause, the United States had become a nation of minorities. Each had to struggle, and to some extent struggles still. To overcome the prejudices not of a monolithic majority, but of a majority composed of various minority groups, of whom it was said, perhaps unfairly in many cases, that a shared characteristic was a willingness to disadvantage other groups. As the nation filled with the stock of many lands, the reach of the clause was gradually extended to all ethnic groups seeking protection from official discrimination. The guarantees of equal protection, said the court in Yickwo, are universal in their application to all persons within the territorial jurisdiction without regard to any differences of race, of color, or of nationality, and the equal protection of the laws is a pledge of the protection of equal laws. Although many of the framers of the 14th Amendment conceived of its primary function as bridging the vast distance between members of the African American race and the white majority, the amendment itself was framed in universal terms without reference to color, ethnic origin, or condition of prior servitude. As this court recently remarked in interpreting the 1866 Civil Rights Act to extend to claims of racial discrimination against white persons, the 39th Congress was intent upon establishing in the federal law a broader principle that would have been necessary simply to meet the particular and immediate plight of the newly freed African American slaves. And that legislation was specifically broadened in 1870 to ensure that all persons, not merely citizens, would enjoy equal rights under the law. Indeed, it is not unlikely that among the framers were many who would have applauded a reading of the Equal Protection Clause that states a principle of universal application and is responsive to the racial, ethnic, and cultural diversity of the nation. Over the past 30 years, this court has embarked upon the crucial mission of interpreting the Equal Protection Clause with the view of assuring all persons the protection of equal laws in a nation confronting a legacy of slavery and racial discrimination. Because the landmark decisions in this area arose in response to the continued exclusion of African Americans from the mainstream of American society, they could be characterized as involving discrimination by the majority white race against the African American minority. But they need not be read as depending upon that characterization for their results. It suffices to say that over the years, this court has consistently repudiated distinctions between citizens solely because of their ancestry as being odious to a free people whose institutions are founded upon the doctrine of equality. Petitioner urges us to adopt for the first time, a more restrictive view of the Equal Protection Clause and hold that discrimination against members of the white majority cannot be suspect if its purpose can be characterized as, quote, benign. The clock of our liberties, however, cannot be turned back to 1868. It is far too late to argue that the guarantee of equal protection to all persons permits the recognition of special wards entitled to a degree of protection greater than that accorded others. The 14th Amendment is not directed solely against discrimination due to a two-class theory that is based upon differences between white and African American. Once the artificial line of a two-class theory of the 14th Amendment is put aside, the difficulties entailed in varying the level of judicial review according to a perceived preferred status of a particular racial or ethnic minority are intractable. The concepts of majority and minority necessarily reflect temporary arrangements and political judgments. As observed above, the white majority itself is composed of various minority groups, most of which can lay claim to a history of prior discrimination at the hands of the state and private individuals. Not all of these groups can receive preferential treatment and corresponding judicial tolerance of distinctions drawn in terms of race and nationality. And for them, the only majority left would be a new minority of white Anglo-Saxon Protestants. There is no principled basis for deciding which groups would merit heightened judicial solitude and which would not. Courts would be asked to evaluate the extent of the prejudice and consequent harm suffered by various minority groups. Those whose societal injury is thought to exceed some arbitrary level of tolerability then would be entitled to preferential classifications at the expense of individuals belonging to other groups. Those classifications would be free from exacting judicial scrutiny. As these preferences began to have their desired effect and the consequences of past discrimination were undone, new judicial rankings would be necessary. The kind of variable sociological and political analysis necessary to produce such rankings simply does not lie within the judicial competence, even if they otherwise were politically feasible and socially desirable. Moreover, there are serious problems of justice connected with the idea of preference itself. First, it may not always be clear that a so-called preference is in fact benign. Courts may be asked to validate burdens imposed upon individual members of a particular group in order to advance the group's general interest. Nothing in the Constitution supports the notion that individuals may be asked to suffer otherwise impermissible burdens in order to enhance the societal standing of their ethnic groups. Second, the preferential programs may only reinforce common stereotypes holding that certain groups are unable to achieve success without special protection based on a factor having no relationship to the individual worth. Third, there is a measure of inequity in forcing innocent persons in respondents' position to bear the burdens of redressing grievances not of their making. By hitching the means of the Equal Protection Clause to these transitory considerations, we would be holding as a constitutional principle that judicial scrutiny of classifications touching on racial and ethnic background may vary with the ebb and flow of political forces. Disparate constitutional tolerance of such classifications may serve to exacerbate racial and ethnic antagonisms rather than alleviate them. Also, the immutability of a constitutional principle based upon shifting political and social judgments undermines the chance for consistent application of the Constitution from one generation to the next, a critical feature of its coherent interpretation. In expounding the Constitution, the court's role is to discern principles sufficiently absolute to give them roots throughout the community and continuity over significant periods of time, and to lift them above the level of the pragmatic political judgments of a particular time and place. If it is the individual who is entitled to judicial protection against classifications upon his race or ethnic background because such distinctions impinge upon personal rights, rather than the individual only because of his membership in a particular group, then constitutional standards may be applied consistently. Political judgments regarding the necessity of the particular classification may be weighed in the constitutional balance, but the standard of justification will remain constant. This is as it should be, since those political judgments are the product of rough compromise struck by contending groups within the democratic process. When they touch upon an individual's race or ethnic background, he is entitled to a judicial determination that the burden he is asked to bear on that basis is precisely tailored to serve a compelling government interest. The Constitution guarantees that that right to every person regardless of his background. Petitioner contends that on several occasions this court has approved preferential classifications without applying the most exacting scrutiny. Most of the cases upon which petitioner relies on are drawn from three areas: school desegregation, employment discrimination, and sex discrimination, each of whom the cases cited presented a situation materially different from the facts of this case. The school desegregation cases are inapposite. Each involves remedies for clearly determined constitutional violations. Racial classifications thus were designed as remedies for the vindication of constitutional entitlement. Moreover, the scope of the remedies was not permitted to exceed the extent of the violations. Here there was no judicial determination of constitutional violation as a predicate for the formulation of a remedial classification. The employment discrimination cases also do not advance petitioner's cause. For example, in Franks v. Bowman Transit Company, we approved a retroactive award of seniority to a class of African American truck drivers who had been the victims of discrimination not just by society at large, but by the respondent in that case. While this relief imposed some burdens on other employees, it was held necessary to make the victims whole for injuries suffered on account of unlawful employment discrimination. The courts of appeals have fashioned various types of racial preferences as remedies for constitutional or statutory violations resulting in identified race-based injuries to individuals held entitled to the preference. Carter v. Gallagher, modified on rehearing en banc. Oh, that's just that. Such preferences also have been upheld where a legislative or administrative body charged with the responsibility made determinations of past discrimination by the industries affected and fashioned remedies deemed appropriate to rectify the discrimination. But we have never approved preferential classifications in the absence of proved constitutional or statutory violations, nor is petitioner's view as to the applicable standard supported by the fact that gender-based classifications are not subjected to this level of scrutiny. Gender-based distinctions are less likely to create the analytical and practical problem present in preferential programs premised on racial or ethnic criteria. With respect to gender, there are only two possible classifications. The incidence of the burdens imposed by preferential classifications is clear. There are no rival groups which can claim that they too are entitled to preferential treatment. Class-wide questions as to the group suffering previous injury and groups which fairly can be burdened are relatively manageable for reviewing courts. The resolution of these same questions in the context of racial and ethnic preferences presents far more complex and intractable problems than gender-based classifications. More importantly, the perception of racial classifications as inherently odious stems from a lengthy and tragic history that gender-based classifications do not share. In sum, the court has never viewed such classification as inherently suspect or as comparable to racial or ethnic classifications for the purpose of equal protection analysis. Petitioner also cites Lau v. Nichols, which in support of the proposition that discrimination favoring racial or ethnic minorities has received judicial approval without the exacting inquiry ordinarily accorded suspect classification. In Lau, we held that the failure of the San Francisco school system to provide remedial English instruction for some 1,800 students of Oriental ancestry who spoke no English amounted to a violation of Title VI of the Civil Rights Act of 1964, and the regulations promulgated thereunder. Those regulations required remedial instruction where inability to understand English excluded children of foreign ancestry from participation in educational programs. Because we found that the students in Lau were denied a meaningful opportunity to participate in the educational program, we remanded for the fashioning of a remedial order. Lau provides little support for petitioner's argument. The decision rests solely on the statute, which had been construed by the responsible administrative agency to reach educational practices which have the effect of subjecting individuals to discrimination. We stated, under these state-imposed standards, there is no equality of treatment merely by providing students with the same faculties, facilities, textbooks, teachers, and curriculum. For students who do not understand English are effectively foreclosed from any meaningful education. Moreover, the preference avoided did not result in the denial of the relevant benefit, meaningful opportunity to participate in the educational program to anyone else. No other student was deprived by that preference of the ability to participate in San Francisco's school system, and the applicable regulations required similar assistance for all students who suffered similar linguistic deficiencies. In a similar vein, petitioner contends that our recent decision in United Jewish Organizations v. Carey indicates a willingness to approve racial classifications designed to benefit certain minorities, without denominating the classifications as suspect. The state of New York had redrawn its reapportionment plan to meet objections of the Department of Justice under subsection 5 of the Voting Rights Act of 1965. Specifically, voting districts were redrawn to enhance the electoral power of certain non-white voters found to have been the victims of unlawful dilution under the original reapportionment plan. United Jewish Organizations, like Lau, properly is viewed as a case in which the remedy for an administrative finding of discrimination encompassed measures to improve the previously disadvantaged group's ability to participate without excluding individuals belonging to any other group from enjoying the relevant opportunity, meaningful participation in the electoral process. In this case, unlike Lau and United Jewish Organizations, there had been no determination by the legislature or a responsible administrative agency that the university engaged in a discriminatory practice requiring remedial efforts. Moreover, the operation of petitioners' special admissions program is quite different from the remedial measures approved in those cases. It preferred the designated minority groups at the expense of other individuals who are totally foreclosed from competition for the 16 special admissions seats in every medical school class. Because of that foreclosure, some individuals are excluded from enjoyment of a state-provided benefit, admission to the medical school, they otherwise would receive. When a classification denies an individual opportunities or benefits enjoyed by others solely because of his race or ethnic background, it must be regarded as suspect. We have held that in order to justify the use of a suspect classification, a state must show that its purpose or interest is both constitutionally permissible and substantial, and that its use of a classification is necessary to the accomplishment of its purpose or the safeguarding of its interest. The special admissions program purports to serve the purposes of 1. Reducing the historic deficit of traditionally disfavored minorities in medical schools and in the medical profession, 2. Countering the effects of societal discrimination, 3. Increasing the number of physicians who will practice in communities currently undeserved, and 4. Obtaining the educational benefits that flow from an ethnically diverse student body. It is necessary to decide which, if any, of these purposes is substantial enough to support the use of a suspect classification. If petitioner's purpose is to assure that within its student body, some specified percentage of a particular group merely because of its race or ethnic origin, such a preferential purpose must be rejected not as insubstantial, but as facially invalid. Preferring members of any one group for no reason other than race or ethnic origin is discrimination for its own sake. This the Constitution forbids. The state certainly has a legitimate and substantial interest in ameliorating or eliminating, where feasible, the disabling effect of identified discrimination. The line of schools desegregation cases, commencing with Brown, attests to the importance of this state goal, and the commitment of the judiciary to affirm all lawful means toward its attainment. In the school cases, the states were required by court order to redress the wrongs worked by specific instances of racial discrimination. That goal was far more focused than the remedying of the effects of societal discrimination, an amorphous concept of injury that may be ageless in its reach into the past. We have never approved a classification that aids persons perceived as members of relatively victimized groups at the expense of other innocent individuals in the absence of judicial, legislative, or administrative findings of constitutional or statutory violations. After such findings have been made, the governmental interest in preferring members of the injured groups at the expense of others is substantial, since the legal rights of the victims must be vindicated. In such a case, the extent of the injury and the consequent remedy will have been judicially, legislatively, and administratively defined. Also, the remedial action usually remains subject to continuing oversight to assure that it will work the least harm possible to other innocent persons competing for the benefit. Without such findings of constitutional or statutory violations, it cannot be said that the government has any greater interest in helping one individual than in refraining from harming another. Thus, the government has no compelling justification for inflicting such harm. Petitioner does not purport to have made and is in no position to make such findings. Its broad mission is education, not the formation of any legislative policy or the adjudication of particular claims of illegality. For reasons similar to those stated in Part 3 of this opinion, isolated segments of our vast governmental structures are not competent to make those decisions, at least in the absence of legislative mandates and legislatively determined criteria. Before relying upon these sorts of findings in establishing a racial classification, a governmental body must have the authority and capability to establish in the record that the classification is responsive to identified discrimination. Lacking this capability, petitioner has not carried its burden of justification on this issue. Hence, the purpose of helping certain groups whom the faculty of the Davis Medical School perceived as victims of societal discrimination does not justify a classification that imposes disadvantages upon persons like respondent who bear no responsibility for whatever harm the beneficiaries of the special admissions program are thought to have suffered. To hold otherwise would be to convert a remedy heretofore reserved for violations of legal rights into a privilege that all institutions throughout the nation could grant at their pleasure to whatever groups are perceived as victims of societal discrimination. That is a step we have never approved. Petitioner identifies as another purpose of its program improving the delivery of healthcare services to communities currently underserved. It may be assumed that in some situations, a state's interest in facilitating the healthcare of its citizens is sufficiently compelling to support the use of a suspect classification. But there is virtually no evidence in the record indicating that petitioner's special admissions program is either needed or geared to promote that goal. The court below addressed this failure of proof. The university concedes it cannot assure that minority doctors who entered under the program, all of whom expressed an interest in practicing in a disadvantaged community, will actually do so. It may be correct to assume that some of them will carry out this intention, and that it is more likely that they will practice in minority communities than the average white doctor. Nevertheless, there are more precise and reliable ways to identify applicants who are genuinely interested in the medical problems of minorities than by race. An applicant of whatever race who has demonstrated his concern for disadvantaged minorities in the past and who declares that practice in such a community is his primary professional goal would be more likely to contribute to alleviation of the medical shortage than one who is chosen entirely on the basis of race and disadvantage. In short, there is no empirical data to demonstrate that any one race is more selflessly socially oriented, or by contrast that another is more selfishly acquisitive. Petitioner simply has not carried its burden of demonstrating that it must prefer members of particular ethnic groups over all other individuals in order to promote better healthcare delivery to deprived citizens. Indeed, petitioner has not shown that its preferential classification is likely to have any significant effect on the problem. The fourth goal asserted by petitioner is the attainment of a diverse student body. This clearly is a constitutionally permissible goal for an institution of higher education. Academic freedom, though not a specifically enumerated constitutional right, long has been viewed as a special concern of the First Amendment. The freedom of a university to make its own judgments as to education includes the selection of its student body. Mr. Frankfurter summarized the four essential freedoms that constitute academic freedom. It is the business of a university to provide that atmosphere which is most conducive to speculation, experiment, and creation. It is an atmosphere in which there prevail the four essential freedoms of a university: to determine for itself on academic grounds who may teach, what may be taught, how it shall be taught, and who may be admitted to study. Our national commitment to the safeguarding of these freedoms within university communities was emphasized in Kaishian v. Board of Regents. Our nation is deeply committed to safeguarding academic freedom, which is of transcendent value to all of us and not merely to the teachers concerned. That freedom is therefore a special concern of the First Amendment. The nation's future depends upon leaders trained through wide exposure to that robust exchange of ideas which discovers truth out of a multitude of tongues rather than through any kind of authoritative selection. The atmosphere of speculation, experiment, and creation, so essential to the quality of higher education, is widely believed to be promoted by a diverse student body. As the court noted in Kaishian, it is not too much to say that the nation's future depends upon leaders trained through wide exposure to the ideas and to the ideas and mores of students and diverse as this nation of many peoples. Thus, in arguing that its universities must be accorded the right to select those students who will contribute the most to the robust exchange of ideas, petitioner invokes a countervailing constitutional interest, that of the First Amendment. In this light, petitioner must be viewed as seeking to achieve a goal that is of paramount importance in the fulfillment of its mission. It may be argued that there is greater force to these views at the undergraduate level than in a medical school, where the training is centered primarily on professional competency. But even at the graduate level, our tradition and expertise lend support to the view that the contribution of diversity is substantial. In Sweat v. Painter, the court made a similar point with specific reference to legal education. The law school, the proving ground for legal learning and practice, cannot be effective in isolation from the individuals and institutions with which the law interacts. Few students and no one who has practiced law would choose to study in an academic vacuum removed from the interplay of ideas and the exchange of views with which the law is concerned. Physicians serve a heterogeneous population. An otherwise qualified medical student with a particular background, whether it be ethnic, geographic, culturally advantaged, or disadvantaged, may bring to a professional school of medicine experiences, outlooks, and ideas that enrich the training of its student body and better equip its graduates to render with understanding their vital service to humanity. Ethnic diversity, however, is only one element in a range of factors a university properly may consider in attaining the goal of a heterogeneous student body. Although a university must have wide discretion in making the sensitive judgments as to who should be admitted, the constitutional limitations protecting individual rights may not be disregarded. Respondents urges, and the courts below have held, that petitioner's dual admissions program is a racial classification that impermissibly infringes his rights under the 14th Amendment. As the interest of diversity is compelling in the context of a university's admissions program, the question remains whether the program's racial classification is necessary to promote this interest. It may be assumed that the reservation of a specified number of seats in each class for individuals from the preferred ethnic groups would contribute to the attainment of considerable ethnic diversity in the student body. But petitioner's argument that this is the only effective means of serving the interest of diversity is seriously flawed. In a most fundamental sense, the argument misconceives the nature of the state interest that would justify consideration of race or ethnic background. It is not an interest in simple ethnic diversity, in which a specified percentage of the student body is in effect guaranteed to be members of selected ethnic groups, with the remaining percentage an undifferentiated aggregation of students. The diversity that furthers a compelling state interest encompasses a far broader array of qualifications and characteristics of which racial or ethnic origin is but a single though important element. Petitioner's special admissions program focuses solely on ethnic diversity, would hinder rather than further attainment of genuine diversity. Nor would the state interest in genuine diversity be served by expanding petitioner's two-track system into a multi-track program with a prescribed number of seats set aside for each identifiable category of applicants. Indeed, it is inconceivable that a university would thus pursue the logic of petitioner's two-track program to the illogical end of insulating each category of applicants with certain desired qualifications from competition with all other applicants. The experience of other university admissions programs, which take race into account in achieving the educational diversity valued by the First Amendment, demonstrates that the assignment of a fixed number of places to a minority group is not a necessary means toward that end. An illuminating example is found in the Harvard College program. In recent years, Harvard College has expanded the concept of diversity to include students from disadvantaged economic, racial, and ethnic groups. Harvard College now recruits not only Californians or Louisianans, but Harvard College now recruits not only Californians or Louisianans, but also blacks and Chicanos and other minority students. In practice, this new definition of diversity has meant that race has been a factor in some admissions decisions. When the Committee of Admissions reviews the large middle group of applicants who are admissible and deemed capable of doing good work in their courses, the race of an applicant may tip the balance in his favor, just as geographic origin or a life spent on a farm may tip the balance in other candidates' cases. A farm boy from Idaho can bring something to Harvard College that a Bostonian cannot offer. Similarly, a black student can usually bring something that a white person cannot offer. In Harvard College, admissions to admit, yeah, in Harvard College, admissions, the committee has not set target quotas for the number of blacks or of musicians, football players, physicists, or Californians to be admitted in a given year. But that awareness of the necessity of including more than a token number of black students does not mean that the committee sets a minimum number of blacks or of people from west of the Mississippi who are to be admitted. It means only that in choosing among thousands of applicants who are not only admissible academically, but have other strong qualities, the committee, with a number of criteria in mind, pays some attention to distribution among many types of categories of students. In such an admissions program, race or ethnic background may be deemed a plus in a particular applicant's file, yet it does not insulate the individual from comparison with all other candidates for the available seats. The file of a particular black applicant may be examined for his potential contribution to diversity without the factor of race being decisive when compared, for example, with that of an applicant identified as an Italian American, if the latter is thought to exhibit qualities more likely to promote beneficial educational pluralism. Such qualities could include exceptional personal talents, unique work or service experience, leadership potential, maturity, demonstrated compassion, a history of overcoming disadvantage, ability to communicate with the poor, or other qualifications deemed important. In short, an admissions program operated in this way is flexible enough to consider all pertinent elements of diversity in light of the particular qualifications of each applicant, and to place them on the same footing for consideration, although not necessarily according them the same weight. Indeed, the weight attributed to a particular quality may vary from year to year, depending upon the mix both of the student body and the applicants for the incoming class. This kind of program treats each applicant as an individual in the admissions process. The applicant who loses out on the last available seat to another candidate receiving a plus on the basis of ethnic background will not have been foreclosed from all consideration for that seat simply because he was not the right color or had the wrong surname. It would mean only that his combined qualifications, which may have included similar non-objective factors, did not outweigh those of the other applicant. His qualifications would have been weighed fairly and competitively, and he would have no basis to complain of unequal treatment under the 14th Amendment. It has been suggested that an admissions program which considers race only as one factor is simply a subtle and more sophisticated, but no less effective, means of according racial preferences than the Davis program. A facial intent to discriminate, however, is evident in petitioner's preference program and not denied in this case. No such facial infirmity exists in an admissions program where race or ethnic background is simply one element to be weighed fairly against other elements in the selection process. A boundary line, as Mr. Justice Frankfurter remarked in another connection, is none the worse for being narrow. And a court would not assume that a university professing to employ a facially non-discriminatory admissions policy would operate it as a cover for that functional equivalent of a quota system. In short, good faith would be presumed in the absence of a showing to the contrary in the manner permitted by our cases. In summary, it is evident that the Davis Special Admissions Program involves the use of an explicit racial classification never before countenanced by this court. It tells applicants who are not African American, Asian, or Chicano that they are totally excluded from a specific percentage of the seats in an entering class. No matter how strong their qualifications, quantitative and extracurricular, including their own potential for contribution to educational diversity, they are never afforded the chance to compete with applicants from the preferred groups for the special admissions seats. At the same time, the preferred applicants have the opportunity to compete for every seat in the class. The fatal flaw in petitioner's preferential program is its disregard of individual rights as guaranteed by the 14th Amendment. Such rights are not absolute. But when a state's distribution of benefits or imposition of burdens hinges on ancestry or the color of a person's skin, that individual is entitled to a demonstration that the challenged classification is necessary to promote a substantial state interest. Petitioner has failed to carry this burden. For this reason, that portion of the California court's judgment holding petitioner's special admissions program invalid under the 14th Amendment must be affirmed. In enjoining petitioner, from ever considering the race of any applicant. However, the courts below failed to recognize that the state has a substantial interest that legitimately may be served by a properly devised admissions program involving the competitive consideration of race and ethnic origin. For this reason, so much of the California court's judgment as enjoins petitioner from any consideration of the race of any applicant must be reversed. With respect to the respondent's entitlement to an injunction directing his admission to the medical school, petitioner has conceded that it could not carry its burden of proving that, but for the existence of its unlawful special admissions program, respondent still would not have been admitted. Hence, respondent is entitled to the injunction, and that portion of the judgment must be affirmed. Oh, this is the appendix. Okay. So for the past 30 years, Harvard College has received each year applications for admissions that greatly exceed the number of places in the freshman class. The number of applicants who are deemed to be not qualified is comparatively small. The vast majority of applicants demonstrate through test scores, high school records, and teachers' recommendations that they have the academic ability to do adequate work at Harvard and perhaps to do it with distinction. Faced with the dilemma of choosing among the large number of qualified candidates, the Committee on Admissions could use the single criterion of scholarly excellence and attempt to determine who among the candidates were likely to perform best academically. But for the past 30 years, the Committee of Admissions has never adopted this approach. The belief has been that if scholarly excellence were the sole or even predominant criterion, Harvard College would lose a great deal of its vitality and intellectual excellence, and that the quality of the educational experience offered to all students would suffer. Consequently, after selecting those students whose intellectual potential will seem extraordinary to the faculty, perhaps 150 or so out of an entering class of over 1,100, the committee seeks variety in making its choices. This has seemed important in part because it adds a critical ingredient to the effectiveness of the educational experience in Harvard College. The effectiveness of our students' educational experience has seemed to the committee to be affected as importantly by a wide variety of interests, talents, backgrounds, and career goals as it is by a fine faculty in our libraries, laboratories, and housing arrangements. The belief that diversity adds an essential ingredient to the educational process has long been a tenet of Harvard College admissions. 15 or 20 years ago, however, diversity meant students from California, New York, and Massachusetts, city dwellers and farm boys, violinists, painters, and football players, biologists, historians, and classicists, potential stockbrokers, academics, and politicians. The result was that very few ethnic or racial minorities attended Harvard College. In recent years, Harvard College has expanded the concept of diversity to include students from disadvantaged economic, racial, and ethnic groups. Harvard College now recruits not only Californians or Louisianans, but also blacks and Chicanos and other minority students. Contemporary conditions in the United States mean that if Harvard College is to continue to offer a first-rate education to its students, minority representation in the undergraduate body cannot be ignored by the Committee of Admissions. In practice, this new definition of diversity has meant that race has been a factor in some admission decisions. When the Committee on Admissions reviews the large middle group of applicants who are admissible and deemed capable of doing good work in their courses, the race of an applicant may tip the balance in his favor, just as geographic origin or a life spent on a farm may tip the balance in other candidates' cases. A farm boy from Idaho can bring something to Harvard College that a Bostonian cannot offer. Similarly, a black student can usually bring something that a white person cannot offer. The quality of the educational experience of all the students at Harvard College depends in part on these differences in the background and outlook that students bring with them. In Harvard College admissions, the committee has not set target quotas for the number of blacks or of musicians, football players, physicists, or Californians to be admitted in a given year. At the same time, the committee is aware that if Harvard College is to provide a truly heterogeneous environment that reflects the rich diversity of the United States, it cannot be provided without some attention to numbers. It would not make sense, for example, to have 10 or 20 students out of 1,100 whose homes are west of the Mississippi. Comparably, 10 or 20 black students could not begin to bring to their classmates and to each other the variety of points of view, backgrounds, and experiences of blacks in the United States. Their small numbers might also create a sense of isolation among the black students themselves and thus make it more difficult for them to develop and achieve their potential. Consequently, when making its decisions, the Committee on Admissions is aware that there is some relationship between numbers and achieving the benefits to be derived from a diverse student body, and between numbers and providing a reasonable environment for those students admitted. But that awareness does not mean that the committee sets a minimum number of blacks or of people from west of the Mississippi who are to be admitted. It means only that in choosing among thousands of applicants who are not only admissible academically but have other strong qualities, the committee, with a number of criteria in mind, pays some attention to distribution among many types and categories of students. The further refinements sometimes required help to illustrate the kind of significance attached to race. The admissions committee, with only a few places left to fill, might find itself forced to choose between A, the child of a successful black physician in an academic community with promise of superior academic performance, and B, a black who grew up in an inner city ghetto of semi-literate parents whose academic achievement was lower but who had demonstrated energy and leadership as well as an apparently abiding interest in black power. If a good number of black students, much like A, but few like B, had already been admitted, the committee might prefer B and vice versa. If C, a white student with extraordinary artistic talent, were also seeking one of the remaining places, his unique quality might give him an edge over both A and B. Thus, the critical criteria are often individual qualities or experience, not dependent upon race, but sometimes associated with it. Opinion of Mr. Justice Brennan, Mr. Justice White, Mr. Justice Marshall, and Mr. Justice Blackmun concurring in the judgment in part and dissenting in part. The court today, in reversing in part the judgment of the Supreme Court of California, affirms the constitutional power of federal and state governments to act affirmatively to achieve equal opportunity for all. The difficulty of the issue presented, whether government may use race-conscious programs to redress the continuing effects of past discrimination, and the mature consideration which each of our brethren has brought to it, have resulted in many opinions, no single one speaking for the court. But this should not and must not mask the central meaning of today's opinion. Government may take race into account when it acts not to demean or to insult any racial group, but to remedy disadvantages cast on minorities by past racial prejudice, at least when appropriate findings have been made by judicial, legislative, or administrative bodies with competence to act in this area. The Chief Justice and our brothers Stewart, Rehnquist, and Stevens have concluded that Title VI of the Civil Rights Act of 1964, as amended, prohibits programs such as that at the Davis Medical School. On this statutory theory alone, they would hold that Respondent Alan Bakke's rights have been violated and that he must therefore be admitted to the medical school. Our brother Powell, reaching the Constitution, concludes that although race may be taken into account in university admissions, the particular special admissions program used by the petitioner, which resulted in the exclusion of Respondent Bakke, was not shown to be necessary to achieve petitioner's stated goals. Accordingly, these members of the court form a majority of 5 affirming the judgment of the Supreme Court of California insofar as it holds that Respondent Bakke is entitled to an order that he be admitted to the university. We agree with Mr. Justice Powell that, as applied to the case before us, Title VI goes no further in prohibiting the use of race than the Equal Protection Clause of the 14th Amendment itself. We also agreed that the effect of the California Supreme Court's affirmance of the judgment of the Superior Court of California would be to prohibit the university from establishing in the future affirmative action programs that take race into account. Since we conclude that the affirmative admissions program at the Davis Medical School is constitutional, we would reverse the judgment below in all respects. Mr. Justice Powell agrees that some uses of race in university admissions are permissible, and therefore he joins with us to make 5 votes reversing the judgment below insofar as it prohibits the university from establishing race-conscious programs in the future. Our nation was founded on the principle that all men are created equal. Yet candor requires acknowledgement that the framers of our Constitution, to forge the 13 colonies into one nation, openly compromised this principle of equality with its antithesis, slavery. The consequences of this compromise are well known and have aptly been called our American dilemma. Still, it is well to recount how recent the time has been, if it has yet come, when the promise of our principles has flowered into the actuality of equal opportunity for all, regardless of race or color. The 14th Amendment, the embodiment in the Constitution of our abiding belief in human equality, has been the law of our land for only slightly more than half its 200 years. And for half of that half, the Equal Protection Clause of the amendment was largely moribund, so that as late as 1927, Mr. Justice Holmes could sum up the importance of the clause by remarking that it was the last resort of constitutional arguments. Worse than desuetude, the clause was early turned against those whom it was intended to set free, condemning them to a separate but equal status before the law, a status always separate but seldom equal. Not until 1954, only 24 years ago, was this odious doctrine interred by our decision in Brown v. Board of Education and its progeny, which proclaimed that separate schools and public facilities of all sorts were inherently unequal and forbidden under our Constitution. Even when inequality was not eliminated with all deliberate speed, in 1968 and again in 1971, for example, we were forced to remind school boards of their obligation to eliminate racial discrimination root and branch. And a glance at our docket and at dockets of lower courts will show that even today, officially sanctioned discrimination is not a thing of the past. Against this background, claims that law must be colorblind or that the datum of race is no longer relevant to public policy must be seen as aspiration rather than as description of reality. This is not to denigrate aspiration, for reality rebukes us that race has too often been used by those who would stigmatize and oppress minorities. Yet we cannot, and as we shall demonstrate, need not under our Constitution or Title VI, which merely extends the constraints of the 14th Amendment to private parties who receive federal funds. Let colorblindness become myopia, which masks the reality that many created equal have been treated within our lifetimes as inferior both by the law and by their fellow citizens. The threshold question we must decide is whether Title VI of the Civil Rights Act of 1964 bars recipients of federal funds from giving preferential treatment consideration to disadvantaged members of racial minorities as part of a program designed to enable such individuals who surmount the obstacles imposed by racial discrimination. We join parts 1 and 5C of our brother Powell's opinion, and 3 of us agree with his conclusion in Part 2, that this case does not require us to resolve the question whether there is a private right of action under Title VI. In our view, Title VI prohibits only those uses of racial criteria that would violate the 14th Amendment if employed by a state or its agencies. It does not bar the preferential treatment of racial minorities as a means of remedying past societal discrimination to the extent that such action is consistent with the 14th Amendment. The legislative history of Title VI, administrative regulations interpreting the statute, subsequent congressional and executive action, and the prior decisions of this court compel this conclusion. None of these sources lend support to the proposition that Congress intended to bar all race-conscious efforts to extend the benefits of federally financed programs to minorities who have been historically excluded from the full benefits of American life. The history of Title VI, from President Kennedy's request that Congress grant executive departments and agencies authority to cut off federal funds to programs that discriminate against African Americans through final enactment of legislation incorporating his proposals, reveals one fixed purpose: to give the executive branch of government clear authority to terminate federal funding of private programs that use race as a means of disadvantaging minorities in a manner that would be prohibited by the Constitution if engaged in by the government. This purpose was first expressed in President Kennedy's June 19, 1963 message to Congress proposing the legislation that subsequently became the Civil Rights Act of 1964. Representative Seller, the chairman of the House Judiciary Committee and the floor manager of the legislation in the House, introduced Title VI in words unequivocally expressing the intent to provide the federal government with the means to assure that its funds were not used to subsidize racial discrimination inconsistent with the standard imposed by the 14th and 5th Amendments upon state and federal action. The bill would offer assurance that hospitals financed by federal money would not deny adequate care to African Americans. It would prevent abuse of food distribution programs whereby African Americans have been known to be denied food surplus supplies when white persons were given such food. It would assure African Americans that the benefits now accorded only white students in programs of higher education financed by federal funding. It would, in short, assure the existing right to equal treatment in the enjoyment of federal funds. It would not destroy any rights of private property or freedom of association. It was clear to Representative Seller that Title VI, apart from the fact that it reached all federally funded activities, even in the absence of sufficient state or federal control to invoke the 14th or 5th Amendments, was not placing new substantive limitations upon the use of racial criteria, but rather was designed to extend to such activities the existing right to equal treatment enjoyed by African Americans under those amendments, and he later specifically defined the purpose of Title VI in this way. In general, it seems rather anomalous that the federal government should aid and abet discrimination on the basis of race, color, or national origin by granting money and other kinds of financial aid. It seems rather shocking, moreover, that while we have on the one hand the 14th Amendment, which is supposed to do away with discrimination since it provides for equal protection of the laws, on the other hand, we have the federal government aiding and abetting those who persist in practicing racial discrimination. It is for these reasons that we bring forth Title VI. The enactment of Title VI will serve to override specific provisions of law which contemplate federal assistance to racially segregated institutions. Representative Seller also filed a memorandum setting forth the legal basis for the enactment of Title VI, which reiterated the theme of his oral remarks. In exercising its authority to fix the terms on which federal funds will be dispersed, Congress clearly has power to legislate so as to ensure that the federal government does not become involved in a violation of the Constitution. Other sponsors of the legislation agreed with Representative Seller that the function of Title VI was to end the federal government's complicity in conduct, particularly the segregation or exclusion of African Americans, inconsistent with the standards to be found in the anti-discrimination provisions of the Constitution. Representative Lindsay, also a member of the Judiciary Committee, candidly acknowledged, in the course of explaining why Title VI was necessary, that it did not create any new standard of equal treatment beyond that contained in the Constitution. Both the federal government and the states are under constitutional mandates not to discriminate. Many have raised the question as to whether legislation is required at all. Does not the executive already have the power in the distribution of federal funds to apply those conditions which will enable the federal government itself to live up to the mandate of the Constitution and to require states and local government entities to live up to the Constitution, most especially the 5th and 14th Amendments? He then explained that legislation was needed to authorize the termination of funding by the executive branch because existing legislation seemed to contemplate the expenditure of funds to support racially segregated institutions. The view of Representatives Seller and Lindsay concerning the purpose and function of Title VI were shared by other sponsors and proponents of the legislation in the House. Nowhere is there any suggestion that Title VI was intended to terminate federal funding for any reason other than consideration of race or national origin by the recipient institution in a manner inconsistent with the standards incorporated in the Constitution. The Senate's consideration of Title VI revealed an identical understanding concerning the purpose and scope of the legislation. Senator Humphrey, the Senate floor manager, opened the Senate debate with a section-by-section analysis of the Civil Rights Act in which he succinctly stated the purpose of Title VI. The purpose of Title VI is to make sure that funds of the United States are not used to support racial discrimination. In many instances, the practices of segregation or discrimination, which Title VI seeks to end, are unconstitutional. This is clearly so wherever federal funds go to a state agency which engages in racial discrimination. It may also be so where federal funds go to support private segregated institutions, under the decision of Simpkins v. Moses H. Cone Memorial Hospital. In all cases, such discrimination is contrary to national policy and to the moral sense of the nation. Thus, Title VI is simply designed to ensure that federal funds are spent in accordance with the Constitution and the moral sense of the nation. Senator Humphrey, in words echoing statements in the House, explained that legislation was needed to accomplish this objective because it was necessary to eliminate uncertainty concerning the power of federal agencies to terminate financial assistance to programs engaging in racial discrimination in the face of various federal statutes which appeared to authorize grants to racially segregated institutions. Although Senator Humphrey realized that Title VI reached conduct which, because of insufficient government action, might be beyond the reach of the Constitution, it was clear to him that the substantive standard imposed by the statute was that of the Fifth and 14th Amendments. Senate supporters of Title VI repeatedly expressed agreement that with Senator Humphrey's description of the legislation that provided the explicit authority and obligation to apply the standards of the Constitution to all recipients of federal funds. Senator Ribicoff described the limited function of Title VI. Basically, there is a constitutional restriction against discrimination in the use of federal funds, and Title VI simply spells out the procedure to be used in enforcing that restriction. Other strong proponents of the legislation in the Senate repeatedly expressed their intent to ensure that federal funds would only be spent in accordance with constitutional standards. Respondents' contention that Congress intended Title VI to bar affirmative action programs designed to enable minorities disadvantaged by the effects of discrimination to participate in federally financed programs is also refuted by an examination of the type of conduct which Congress thought it was prohibiting by means of Title VI. The debates reveal that the legislation was motivated primarily by a desire to eradicate a very specific evil: federal financial support of programs which disadvantaged African Americans by excluding them from participation or providing them with separate facilities. Again and again, supporters of Title VI emphasized that the purpose of the statute was to end segregation in federally funded activities and to end other discriminatory uses of race disadvantaging African Americans. Senator Humphrey set the theme in his speech presenting Title VI to the Senate. Large sums of money are contributed to the United States each year for the construction, operation, and maintenance of segregated schools. Similarly, under the Hill-Burton Act, federal grants are made to hospitals which admit whites only or African Americans only. In higher education, also, a substantial part of the federal grants to colleges, medical schools, and so forth in the South is still going to segregated institutions. Nor is this all. In several states, agricultural extension services, supported by federal funds, maintain racially segregated offices for African Americans and whites. Vocational training courses supported with federal funds are given in segregated schools and institutions and often limit African Americans to training in less skilled occupations. In particular localities, it is reported that African Americans have been cut off from relief roles or denied surplus agricultural commodities or otherwise deprived of the benefit of federally assisted programs in retaliation for their participation in voter registration drives, sit-in demonstrations, and the like. The conclusion to be drawn from the foregoing is clear. Congress recognized that African Americans, in some cases with congressional acquiescence, were being discriminated against in the administration of programs and denied the full benefits of activities receiving federal financial support. It was aware that there were many federally funded programs and institutions which discriminated against minorities in a manner inconsistent with the standards of the Fifth and 14th Amendments, but whose activities might not involve sufficient state or federal action so as to be in violation of these amendments. Moreover, Congress believed that it was questionable whether the executive branch possessed legal authority to terminate the funding of activities on the ground that they discriminated racially against African Americans in a manner violative of the standards contained in the 14th and 5th Amendments. Congress's solution was to end the government's complicity in constitutionally forbidden racial discrimination by providing the executive branch with the authority and the obligation to terminate its financial support of any activity which employed racial criteria in a manner condemned by the Constitution. Of course, it might be argued that the Congress which enacted Title VI understood the Constitution to require strict racial neutrality or colorblindness and then enshrined that concept as a rule of law. Later interpretation and clarification of the Constitution would permit remedial use of race would then not dislodge Title VI's prohibition of race-conscious action. But there are three compelling reasons to reject such a hypothesis. First, no decision of this court has ever adopted the proposition that the Constitution must be colorblind. Second, even if it could be argued in 1964 that the Constitution might conceivably require colorblindness, Congress surely would not have chosen to codify such a view unless the Constitution clearly required it. The legislative history of Title VI, as well as the statute itself, reveals a desire to induce voluntary compliance with the requirement of non-discriminatory treatment. It is inconceivable that Congress intended to encourage voluntary efforts to eliminate the evil of racial discrimination while at the same time forbidding the voluntary use of race-conscious remedies to cure acknowledged or obvious statutory violations. Yet a reading of Title VI as prohibiting all action predicated upon race which adversely affects any individual would require recipients guilty of discrimination to await the imposition of such remedies by the executive branch. Indeed, such an interpretation of Title VI would prevent recipients of federal funds from taking race into account even when necessary to bring their programs into compliance with federal constitutional requirements. This would be a remarkable reading of a statute designed to eliminate constitutional violations, especially in light of judicial decisions holding that under certain circumstances, the remedial use of racial criteria is not only permissible, but is constitutionally required to eradicate constitutional violations. For example, in Board of Education v. Swan, the court held that a statute forbidding the assignment of students on the basis of race was unconstitutional because it would hinder the implementation of remedies necessary to accomplish the desegregation of a school system. Just as the race of students must be considered in determining whether a constitutional violation has occurred, so also must race be considered in formulating a remedy. Surely Congress did not intend to prohibit the use of racial criteria when constitutionally required, or to terminate the funding of any entity which implemented such a remedy. It clearly desired to encourage all remedies, including the use of race, necessary to eliminate racial discrimination in violation of the Constitution, rather than requiring the recipient to await a judicial adjudication of unconstitutionality and the judicial imposition of a racially oriented remedy. Third, the legislative history shows that Congress specifically eschewed any static definition of discrimination in favor of broad language that could be shaped by experience, administrative necessity, and evolving judicial doctrine. Although it is clear from the debates that the supporters of Title VI intended to ban uses of race prohibited by the Constitution and, more specifically, the maintenance of segregated facilities, they never precisely defined the term discrimination, or what constituted an exclusion from participation or a denial of benefits on the ground of race. This failure was not lost upon its opponents. Senator Ervin complained, "The word discrimination, as used in this reference, has no contextual explanation whatsoever, other than the provision that the discrimination is to be against individuals participating in or benefiting from federally assisted programs and activities on the ground specified. With this context, the discrimination condemned by this reference occurs only when an individual is treated unequally or unfairly because of his race, color, religion, or national origin. What constitutes unequal or unfair treatment? Section 601 and Section 602 of Title VI do not say. They leave the determination of that question to the executive department or agencies administering each program, without any guideline whatever to point out what is the congressional intent." Despite these criticisms, the legislation's supporters refused to include in the statute or even provide in debate a more explicit definition of what Title VI prohibited. The explanation for this failure is clear. Specific definitions were undesirable. In the views of the legislation's principal backers, because Title VI's standard was that of the Constitution and one that could and should be administratively and judicially applied, Indeed, there was a strong emphasis throughout Congress's considerations of Title VI on providing the executive branch with considerable flexibility in interpreting and applying the prohibition against racial discrimination. Attorney General Robert Kennedy testified that regulations had not been written into the legislation itself because the rules and regulations defining discrimination might differ from one program to another, so that the term would assume different meanings in different contexts. This determination to preserve flexibility in the administration of Title VI was shared by the legislation's supporters. When Senator Johnson offered an amendment that would have expressly authorized federal grantees to take race into account in placing children in adoptive and foster homes, Senator Pastor opposed the amendment, which was ultimately defeated by a vote of 56 to 29 vote. on the ground that federal administrators could be trusted to act reasonably and that there was no danger that they would prohibit the use of racial criteria under such circumstances. Congress resolved not to incorporate a static definition of discrimination into Title VI is not surprising. In 1963 and 1964, when Title VI was drafted and debated, the courts had only recently applied the Equal Protection Clause to strike down public racial discrimination in America, and the scope of that clause's non-discrimination principle was in a state of flux and rapid evolution. Many questions, such as whether the 14th Amendment barred only de jure discrimination, or in at least some circumstances reached de facto discrimination, had not yet received an authoritative judicial resolution. The congressional debate reflects an awareness of the evolutionary change that constitutional law in the area of racial discrimination was undergoing in 1964. In sum, Congress's equating of Title VI's prohibition with the command of the Fifth and 14th Amendments, its refusal precisely to define that racial discrimination which it intended to prohibit, and its expectation that the statute would be administered in a flexible manner, compel the conclusion that Congress intended the meaning of the statute's prohibition to evolve with the interpretation of the commands of the Constitution. Thus, any change that the use of racial criteria is barred by the plain language of the statute must fail in light of the remedial purpose of Title VI and its legislative history. The cryptic nature of the language employed in Title VI merely reflects Congress's concern with the then prevalent use of racial standards as a means of excluding or disadvantaging African Americans and its determination to prohibit absolutely such discrimination. We have recently held that when aid to construction of the meaning of words as used in the statute is available, there certainly can be no rule of law which forbids its use, however clear the words may appear on superficial examination. This is especially so, as is the case here. The literal application of what is believed to be the plain language of the statute, assuming that it is so plain, would lead to results in direct conflict with Congress's unequivocal expressed legislative purpose. Section 602 of Title VI instructs federal agencies to promulgate regulations interpreting Title VI. These regulations, which under the terms of the statute require presidential approval, are entitled to considerable deference in construing Title VI. Consequently, it is most significant that the Department of Health, Education, and Welfare, HUE, which provides much of the federal assistance to institutions of higher education, has adopted regulations requiring affirmative measures designed to enable racial minorities which have been previously discriminated against by a federally funded institution or program to overcome the effect of such actions, and authorizing the voluntary undertaking of affirmative action programs by federally funded institutions that have not been guilty of prior discrimination in order to overcome the effects of conditions which have adversely affected the degree of participation by persons of a particular race. Title 45 provides, in administering a program regarding which the recipient has previously discriminated against persons on the ground of race, color, or national origin, the recipient must take affirmative action to overcome the effects of prior discrimination. Title 45, the first one was Title 45, CFR subsection 80-03, B6I. Title 45, CFR subsection 80.5, I, elaborates upon this requirement. In some situations, even though past discriminatory practices attributable to a recipient or applicant have been abandoned, the consequences of such practices continue to impede the full availability of a benefit if the efforts required of the applicant or recipient under subsection 80.6d to provide information as to the availability of the program or activity and the rights of beneficiaries under this regulation have failed to overcome these consequences. It will become necessary under the requirement stated in I of subsection 80.3b6 for such applicant or recipient to take additional steps to make the benefits fully available to racial and nationality groups previously subject to discrimination. This action might take the form, for example, of special arrangements for obtaining referrals or making selections which will ensure that groups previously subjected to discrimination are adequately served. These regulations clearly established that there were that where there is a need to overcome the effects of past racially discriminatory or exclusionary practices engaged in by a federally funded institution, race-conscious action is not only permitted but required to accomplish the remedial objectives of Title VI. Of course, there is no evidence that the medical school has been guilty of past discrimination, and consequently, these regulations would not compel it to employ a program of preferential admission in behalf of racial minorities. It would be difficult to explain from the language of Title VI, however, much less from its legislative history, why a statute compels race-conscious remedies where a recipient instituted has engaged in past discrimination, but prohibits such remedial action where racial minorities, as a result of the effect of past discrimination imposed by entities other than the recipient, are excluded from the benefits of federally funded programs. Hugh was fully aware of the incongruous nature of such an interpretation of Title VI. Title 45, subsection 80.3b6 II provides, even in the absence of such prior discrimination, a recipient in administering a program may take affirmative action to overcome the effect of conditions which resulted in limiting participation by persons of a particular race, color, or national origin. An explanatory regulation explicitly states that the affirmative action which subsection 80.3b6 II contemplates includes the use of racial preferences. Even though an applicant or recipient has never used discriminatory policies, the services and benefits of the program or activity it administers may not, in fact, be equally available in some racial or nationality groups. In such circumstances, an applicant or recipient may properly give special consideration to race, color, or national origin to make the benefits of its program more widely available to such groups, not then being adequately served. For example, where a university is not adequately serving members of a particular racial or nationality group, it may establish special recruitment policies to make its program better known and more readily available to such group, and take other steps to provide that group with more adequate service. This interpretation of Title VI is fully consistent with the statute's emphasis upon voluntary remedial action and reflects the view of an agency responsible for achieving its objectives. The court has recognized that the construction of a statute by those charged with its execution is particularly deserving of respect, where Congress has directed its attention to the administrative construction and left it unaltered. Congress recently took just this kind of action when it considered an amendment to the Departments of Labor and Health, Education, and Welfare Appropriation Bill for 1978, which would have restricted significantly the remedial use of race in programs funded by the appropriation. The amendment, as originally submitted by Representative Ashbrook, provided that none of the funds appropriated in this act may be used to initiate, carry out, or enforce any program of affirmative action or any other system of quotas or goals in regards to admissions policies or employment practices which encourage or require any discrimination on the basis of race, creed, religion, sex, or age. In support of the measure, Representative Ashbrook argued that the 1964 Civil Rights Act never authorized the imposition of affirmative action and that this was a creation of the bureaucracy. He explicitly stated, however, that he favored permitting universities to adopt affirmative action programs, giving consideration to racial identity, but opposed the imposition of such programs by the government. His amendment was itself amended to reflect this position by only barring the imposition of race-conscious admissions by Hugh. None of the funds appropriated in this act may be obligated or expended in connection with the issuance, implementation, or enforcement of any rule, regulation, standard, guideline, recommendation, or order issued by the Secretary of Health, Education, and Welfare, which, for purposes of compliance with any ratio, quota, or other numerical requirement related to race, creed, color, national origin, or sex, requires any individual or entity to take any action with respect to 1. The hiring or promotion policies or practices of such individual or entity, or 2. The admissions policies or practices of such individual and entity. This amendment was adopted by the House. The Senate bill, however, contained no such restriction upon Hugh's authority to impose race-conscious remedies, and the conference committee, upon the urging of the Secretary of Hugh, deleted the House provision from the bill. More significant for present purposes, however, is the fact that even the proponents of imposing limitations upon Hughes' implementation of Title VI did not challenge the right of federally funded educational institutions voluntarily to extend preferences to racial minorities. Finally, congressional action subsequent to the passage of Title VI eliminates any possible doubt about Congress's views concerning the permissibility of racial preferences for the purpose of assisting disadvantaged racial minorities. It confirms that Congress did not intend to prohibit and does not now believe that Title VI prohibits the consideration of race as part of a remedial or societal discrimination, even where there is no showing that the institution extending the preference has been guilty of past discrimination, nor any judicial finding that the particular beneficiaries of the racial preference have been adversely affected by societal discrimination. Just last year, Congress enacted legislation explicitly requiring that no grants shall be made for any local public works project unless the applicant gives satisfactory assurance to the Secretary of Commerce that at least 10% of the amount of each grant shall be expended for minority business enterprises. The statute defines the term minority business enterprise as a business at least 50% of which is owned by minority group members, or in case of a publicly owned business, at least 51% of the stock of which is owned by minority group members. The term minority group members is defined in explicitly racial terms. Citizens of the United States who are African Americans, Spanish-speaking, Orientals, Indians, Eskimos, or Aleuts. Although the statute contains an exemption from this requirement to the extent that the Secretary determines otherwise. This escape clause was provided only to deal with the possibility that certain areas of the country might not contain sufficient qualified minority business enterprises to permit compliance with the quota provisions of the legislation. The legislative history of this race-conscious legislation reveals that it represents a deliberate attempt to deal with the excessive rates of unemployment among minority citizens and to encourage the development of viable minority-controlled enterprises. It was believed that such a set-aside was required in order to enable minorities still new on the scene and relatively small to compete with larger and more established companies, which would always be successful in underbidding minority enterprises. What is more significant about the congressional consideration of the measure is that although the use of racial quota or set-aside by a recipient of federal funds would constitute a direct violation of Title VI if that statute were read to prohibit race-conscious action, no mention was made during the debates in either the House or Senate of even the possibility that the quota provisions for minority contractors might in any way conflict with or modify Title VI. It is inconceivable that such a purported conflict would have escaped congressional attention through the inadvertent failures to recognize the relevance of Title VI. Indeed, the act of which this affirmative action provision is a part also contains a provision barring discrimination on the basis of sex, which states that this prohibition will be enforced through agency provisions and rules similar to those already established with respect to racial and other discrimination under Title VI of the Civil Rights Act of 1964. Thus, Congress was fully aware of the applicability of Title VI to the funding of public works projects. Under these circumstances, the enactment of the 10% set aside for minority enterprises reflects a congressional judgment that the remedial use of race is permissible under Title VI. We have repeatedly recognized that subsequent legislation reflecting an interpretation of an earlier act is entitled to great weight in determining the meaning of the earlier statute. Prior decisions of this court also strongly suggest that Title VI does not prohibit the remedial use of race where such action is constitutionally permissible. In Lau v. Nichols, the court held that the failure of the San Francisco school system to provide English language instruction to students of Chinese ancestry who do not speak English, or to provide them with instruction in Chinese, constituted a violation of Title VI. The court relied upon an HEW regulation which stipulates that a recipient of federal funds may not utilize criteria or methods of administration which have the effect of subjecting individuals to discrimination, or have the effect of defeating or substantially impairing accomplishment of the objectives of the program as respect individuals. Let me back up. The effect of defeating or substantially impairing accomplishment of the objectives of the program as as respect individuals of a particular race, color, or national origin. It interpreted this regulation as requiring San Francisco to extend the same educational benefits to Chinese-speaking students as to English-speaking students, even though there was no finding or allegation that the city's failure to do so was a result of a purposeful design to discriminate on the basis of race. Lao is significant in two related respects. First, it indicates that in at least some circumstances, agencies responsible for the administration of Title VI may require recipients who have not been guilty of any constitutional violations to depart from a policy of colorblindness and to be cognizant of the impact of their actions upon racial minorities. Secondly, Lao clearly requires that institutions receiving federal funds be accorded considerable latitude in voluntarily undertaking race-conscious action designed to remedy the exclusion of significant numbers of minorities from the benefits of federally funded programs. Although this court has not yet considered the question, presumably by analogy to our decisions construing Title VII, a medical school would not be in violation of Title VI under Lao because of the serious underrepresentation of racial minorities in its student body, as long as it could demonstrate that its entrance requirements correlated sufficiently with the performance of minority students in medical school and the medical profession. It would be inconsistent with Lao and the emphasis of Title VI and the HEW regulations on voluntary action, however, to require that an institution wait to be adjudicated to be in violation of the law before being permitted to voluntarily undertake corrective action based upon a good faith and reasonable belief that the failure of certain racial minorities to satisfy entrance requirements is not a measure of their ultimate performance as doctors, but a result of the lingering effect of past societal discrimination. We recognize that Lao, especially when read in light of our subsequent decision in Washington v. Davis, which rejected the general proposition that governmental action is unconstitutional solely because it has a racially disproportionate impact, may be read as being predicated upon the view that, at least under some circumstances, Title VI proscribes conduct which might not be prohibited by the Constitution. Title VI prescribes conduct which might not be prohibited by the Constitution. Since we are now of the opinion, for the reasons set forth above, that Title VI's standard, applicable alike to public and private recipients of federal funds, is no broader than the Constitution's, we have serious doubts about concerning the correctness of what appears to be the premise of that decision. However, even accepting Lao's implication that impact alone is in some contexts sufficient to establish a prima facie violation of Title VI, contrary to our view that Title VI's definition of racial discrimination is absolutely coextensive with the Constitution's, this would not assist the respondent in the least. First, for the reasons discussed, regardless of whether Title VI's prohibitions extend beyond the Constitution's, the evidence fails to establish, and indeed compels the rejection of, the proposition that Congress intended to prohibit recipients of federal funds from voluntarily employing race-conscious measures to eliminate the effects of past societal discrimination against racial minorities such as African Americans. Secondly, Lao itself, for the reasons set forth in the immediately preceding paragraph, strongly supports the view that voluntary race-conscious remedial action is permissible under Title VI. If discriminatory racial impact alone is enough to demonstrate that at least a prima facie Title VI violation, it is difficult to believe that the title would forbid the medical school from attempting to correct the racially exclusionary effects of its initial admissions policy during the first 2 years of the school's operation. The court also declines to adopt a colorblind interpretation of other statutes containing non-discrimination provisions similar to that contained in Title VI. We have held under Title III that where employment requirements have a disproportionate impact upon racial minorities, they construe a statutory violation even in the absence of discriminatory intent, unless the employer is able to demonstrate that the requirements are sufficiently related to the needs of the job. More significantly, the court has required that preferences be given by employers to members of racial minorities as a remedy for past violations of Title VII, even where there has been no finding that the employer has acted with a discriminatory intent. Finally, we have construing the Voting Rights Act of 1965, which contains a provision barring any voting procedure or qualification that denies or abridges the right of any citizen of the United States to vote on account of race or color, as permitting the states to voluntarily take race into account in a way that fairly represents the voting strengths of different racial groups in order to comply with the commands of the statute, even where the result is a gain for one racial group at the expense of others. These prior decisions are indicative of the court's unwillingness to construe remedial statutes designed to eliminate discrimination against racial minorities in a manner which would impede efforts to attain this objective. There is no justification for departing from this course in the case of Title VI and frustrating the clear judgment of Congress that race-conscious remedial action is permissible. We turn, therefore, to our analysis of the Equal Protection Clause of the 14th Amendment. Okay, so that's good for part one. I will finish up part two shortly. And as always, if there's any case you'd like me to read, just drop it in the comments, and I'd be happy to take a look. Thank you.